Welcome to Future Knowledge, a podcast about knowledge, creativity, and policy, brought to you by the Internet Archive and Authors Alliance. So imagine this. You're a content creator, and that's not hard to imagine because it seems like everybody is today. And you accidentally capture some recent music in the background of your latest video, and you wonder, can I share this video? Am I going to get a copyright strike on my platform of choice if I put this video online? In a world where digital media is everywhere, copyright feels like a constant shadow and a potential threat. But there's a powerful legal tool that helps us all engage with content. That legal tool is fair use, and frankly, most of us don't fully understand its potential. Hi, everyone. I'm Chris Freeland, and I'm a librarian at the Internet Archive. I want to welcome you to today's book talk. Today, we're diving into Reclaiming Fair Use by Patricia Aufderheide and Peter Jaszi, a transformative guide now in its second edition that helps demystify copyright law. The authors remind us that fair use isn't a loophole, it's a vital principle that is embedded in copyright law itself. And here to lead our conversation today is Dave Hansen, Executive Director of Authors Alliance, our co-host for these talks, and the facilitator for today's conversation.
Hi, everyone. So this book, I really don't recommend that many books about copyright law to like normal people. That is like not lawyers, not, people who are way down in the depths of the law. It's usually not all that helpful to say, go read a, 300 page book about this. But this book, Reclaiming Fair Use, I have probably recommended over 500 times to people in practice when they come to me and they ask me about how fair use works in real life and how fair use applies to the kinds of creative works that authors and other creators are producing. And this is one of the few books that really hits that sweet spot of addressing both how the law works and what it actually means for people every day. So one of the neat things about this book and the best practices movement really that Peter and Pat have led is that it addresses a lot of those kinds of uses that seem, at least to some of us, almost obvious and certainly routine. And I think that's a really important part of fair use and copyright law practice that sometimes gets skipped over. It's really interesting to kind of debate the finer points of where the edges of fair use are, or the edges of copyright law more generally. So it's really important that people understand how fair use applies to very practical situations that occur across a whole variety of communities of practice. And so that's one of the reasons why this is just a really special book and a really, really important one for folks to consider as they think about their own creative work. Peter is a world-renowned expert on copyright law. The copyright textbook that I had in law school has his name right on the side, along with several other co-authors. He's an emeritus professor of law at the Washington College of Law, American University in Washington, D.C. He's also the founder of their program on information justice and intellectual property and of the Glushko Samuelson Intellectual Property Law Clinic. And he's been deeply involved in copyright law and policy debates for many years, including some of the most intense, most dramatic debates, I think, that we've seen in the last 100 years, leading to the enactment of the DMCA and fighting very, very hard for some of the public interest protections that were secured during that. And then Patricia Aufderheide is a university professor of communication studies in the School of Communication at American University as well. She founded the school's Center for Media and Social Impact, where she continues as a senior research fellow. It is on the Center for Media and Social Impact website that you will find an incredible wealth of information about fair use, including numerous different fair use best practices that the Center for Media and Social Impact has helped shepherd along with Peter to help a whole variety of communities, from people in poetry to documentary filmmakers to museums to research libraries. It's really, really incredible. She has been a Fulbright Research Fellow in numerous places, but the most recent is in South Korea. And we're going to hear her talk, I think, a little bit about some of what she's been doing in South Korea. So with those introductions, tell us the story of the idea of this book and how you came to the point of the second edition.
Well, I had gotten interested after having had a career at American University Law School teaching and writing a little bit about copyright topics, I'd gotten interested more and more in the question of how copyright was being consumed, understood, processed by individuals who were subject to this mode of regulations. And so I decided that I would try to identify people from other disciplines who would be interested in having that kind of conversation. And Pat, who was right across campus, but who I had not known previously, was an obvious candidate because she was so deeply immersed in, both as a scholar and writer and as a teacher practitioner, the world of documentary film. So we started to talk. Well, first we started to talk about copyright in general, and we very quickly focused in together on the ways in which copyright law was, for lack of a better word, I'll say, burdening the practice of documentary filmmaking.
I just have to say, I sat through a whole conference of his, of lawyers talking about this stuff, and I was like, that sounds very convincing. Copyright, bad for creators. Sounds right. The problem is, and I was like, Peter, that all sounds good. So my people, filmmakers, never complain about this. They just talk about how people are going to steal their stuff in a digital environment. Do you have any data that shows that this is a problem? And he's like, oh no, lawyers don't do data. We do ideas. And I was like, well, if you're going to talk to my people, you might need some data because I don't think they currently believe they have a problem. And that was where it began, because Peter and I got a grant from the Rockefeller Foundation to go ask them. And let me tell you, TLDR, we go ask them and they're like, actually, I don't have copyright problems like that because I'm a professional. What? Professional? And they're like, professionals never undertake projects that they can't do. And we were like, really? Could you tell us more about the projects you would never undertake because it would be impossible? And that's when the cornucopia of great information started falling out. And of course, like, these are people who are telling truth to power, only they can't talk about current events because it involves TV footage, and they can't talk about popular music, and they can't talk about popular film, and they don't want to be funny or ironic because people might misunderstand. They might have to refer to something. They are told by places like Discovery to carry with them canned, cleared music to substitute for whatever people are playing in the scene. Suddenly, we got a really good case. I was somebody who needed data to convince me.
Absolutely. And to convince others, and to convince the very subject group that there was actually a problem. And once we had that in hand, then there was a question about, next steps, what to do. Because what we understood immediately, this is around 2005, is that the filmmakers who we had been speaking with and who had eventually provided this thick description of all of the ways in which copyright was, in fact, flattening their creativity, hadn't benefited at all from the single most important doctrine in U.S. copyright law for their purposes, which is the fair use doctrine that started out in the 19th century and got codified in the 1976 Copyright Act, and then was interpreted this way and that way by the courts until in 1994, in the case of Campbell against Acuff Rose, the Supreme Court sort of provided us with a synthesis, a workable synthesis of copyright law that could be applied to practice in a variety of different fields. Trouble was, 10 years had passed and no one knew about this. Lawyers weren't telling them. No one with whom they were in communication was telling them. In fact, the only legal authorities that they had regular access to were telling them that it was still a fraught and dangerous legal landscape. So what to do? And we came up with the notion that...
Peter came up with the notion.
Really? I don't remember. The notion arose that it would be interesting to create with filmmakers and for filmmakers a consensus document describing how they believed this doctrine should work for them.
Let me just say that they were vastly suspicious. They were like, "Oh, you're gonna offer us lunch? Yes, we will show up, but we don't believe that this will make any difference." And then it did.
And then it did. And our methodology was, I think, very straightforward. And that is, we fed them, very important, or promised to feed them with MacArthur money. Thank goodness for that. We traveled around to wherever they were to be found, because this was all before the age of Zoom. So the only way to get groups of 15 or 20 filmmakers together to have a long form conversation was to go to where they were. So we were on the road for a while. And in each meeting, we did essentially several different things. We told them a little about the current state of copyright law, the truth about copyright law, and what legal authorities said about it, and how important the Supreme Court had reorganized copyright analysis around the idea of transformative use. So we gave them a little information. And then we talked for quite a long time about how they thought the principles that we had described might apply reasonably and fairly to things that they did recurrently, to situations that came up again and again in their practice, to the critical use of copyrighted works, to the illustrative use of copyrighted works, to the incidental use of copyrighted works, and to certain recurring difficult situations involving archival images and footage. And over the course of our conversation, we came to a kind of a consensus about that. And each conversation that we had, the conversation in Chicago, built on the conversation that we had had in Los Angeles. And so by the end of, I don't know what it was, 10 months of wandering, we were ready to write what we thought was a synthesis of the views of the small groups that we had convened around the country. And then that synthesis was vetted by a kind of, a blue ribbon panel of lawyers who hadn't had anything previously to do with the project, and who were asked to give their views about what the filmmakers had said about how this area or body of law should apply to them was reasonable. We didn't ask the lawyers to say whether it was right, because there weren't any, and still aren't for the most part, any law cases decided about this subject. So we asked these experts instead to say whether the filmmakers were in effect coloring within the lines, making reasonable, responsible, middle of the road projections about how this law could and should work for them. And we made a few nips and tucks in the document as a result of those legal consultations. And then we published what was also with MacArthur support, the Statement of Best Practices and Fair Use for Documentary Filmmakers. It was called a statement. The later ones got to be called codes. The first one was called a statement.
Funders, they're so important. MacArthur Foundation was like, "Oh, you can't have a code of practices. You have to have a statement." And we were like, "Fine, we'll call it a statement." And then journalism, and they were like, "Well, we can't have a code because that's a problem with our lawyers." And we were like, "Okay, we'll call it a set of principles." And you can call it Fred, but its function was like that. I wanted to say that at this point, also Ford comes in, and Ford creates the opportunity for us to heavily invest in promotion. So we launched this with articles about this code in every major journal and magazine that showed up at Sundance, for Sundance. And then we showed up at Sundance, which was kind of hilarious. And we had a table in this event spot. And when we'd walk by, the people from PETA, the animal people, they'd be like, oh, did you see? Fair use just came in. And I thought, like, that's what they're going to, I should just have it on my forehead. But this promotional and educational campaign, which went on for years, was actually really important because the entrenched knowledge was, oh, this just can't be done. One of the people who's really important in the film industry, a lawyer who's important in the film industry, Michael Donaldson, actually came in thanks to Peter, who convinced him that fair use was a thing, started seeing a real market opportunity. And thank God, because he became somebody who also would show up at every film festival and be on all these panels. But what you had to do was really come in and change the language in which people thought opportunity, change the Overton window, basically. So this was still pioneering. It was still totally imaginary whether this would work. And what really changed it was that the insurers, thanks to some brokers who were really zealous, as well as Michael Donaldson and the guy who ran POV at the time, Simon Kilmurray, they all went after insurance brokers to say, there's a new tool to help you assess risk. You could really start insuring for errors and omissions on fair use. And people would be like, I never do that. We don't know what risk factors are. And Rockefeller let us use their building in New York to convene a bunch of executives to explain it. And they were like, doesn't seem like, talk to the insurers. I don't know. So the insurers were really crucial. And one of the insurers was like, this all makes sense. I see what risk looks like now. And I just saw a film that I could insure. There's only 4 at the time, only 4 insurers in the country. And insurer 1 says, I can insure this film. I'm pretty sure it's exactly within the best practices code, which it was because we helped. And they insure, and they put a big announcement like, we insure for fair use. The other 3, they're like, oh, we do too. We've always insured for fair use. Come over here. So suddenly, 6 months into this, insurers flip and start insuring for fair use. And that changes what broadcasters think. Broadcasters are now like, that looks good. Okay, fine. Because I don't have any risk anymore. And now our big target is film teachers. Because film production teachers only want to teach production practice. So now, I'm going to their conferences and I'm like, have a panel on fair use. And I just got to thank the funders for sending me all those places. But that initial project, because it was so successful in actually changing industry practice on the basis only of what creators thought was a reasonable use of this law in ordinary practice, that opened the door to the next 14 best practices codes. What everybody else could now say is, well, they did it. Why don't we do that? And all that had been done is that people had articulated what is garden variety normal behavior anyway. And they hadn't been doing that garden variety normal behavior because they were like, oh, this looks legal and it looks risky. And also, these gatekeepers don't accept it. And having the creator's opinion changed everything. Basically, the book that we wrote the first time was like, this is what is possible, people. This could improve your life. Understanding how copyright law works and why balance is a key feature in it in order to make sure the First Amendment isn't overridden. Good idea for you. Makes your life easier. That's book 1. The second edition comes in after at least 12 more creator groups have come in and is a document of the success of this idea in practice. So the first one seems like a good idea. The second one is really good idea.
It's a wonderful summary. And what I would like to do is we can talk more about documentary filmmaking if it is so desired. It's very near and dear to both of us. But I'd like to shift and just give you a quick example of how this works in a different setting, and a setting in which, as it turns out, one of these best practices codes may actually have been quite influential. So this is a story about a photograph of a recently deceased sort of rock and roll hero that was used without authorization by an entity and led then to a lawsuit on the part of the photographer who had taken that picture. And so far, some of you think that I may be describing the recent Supreme Court case between the Andy Warhol Foundation and a photographer whose picture of Prince had been incorporated by Warhol into an illustration that eventually found its way into the magazine, and so forth and so on. But I'm not. I'm actually talking about a 2021 Second Circuit decision called Murano against the Metropolitan Museum of Art. The Met had a big exhibit of famous rock and roll instruments, including Eddie Van Halen's Frankenstein guitar. And with the guitar itself, both in the physical exhibit and in the catalog and in the online display related, was a photograph by Lawrence Murano of Eddie Van Halen in performance playing this guitar. The Met won in the district court at the trial. The photographer appealed to the Second Circuit Court of Appeals. The Met, in support of its defense, its winning defense of fair use, cited to the College Art Association Code of Best Practices for the Visual Arts, one of the successors to the filmmakers' statement of best practices. And the decision, which was an easy and non-controversial decision, like so many of the other things covered in the Derfarin codes, said this about why the photograph was a fair use. Whereas I'm reading now from the decision, whereas Murano's stated purpose in creating the photo was to show what Van Halen looks like in performance, the Met exhibition highlights the unique design of the Frankenstein guitar and its significance in the development of rock and roll instruments. The original use and the use accused of being infringing was non-infringing precisely because it was undertaken for a new and different purpose. And that transformativeness analysis, which originates with the 1994 Supreme Court opinion in Campbell, which I referenced early, is the sort of the legal engine that is driving or powering the codes of best practices to which Pat referred across disciplines. And that's how it's worked in discipline after discipline as the codes have rolled out over time, and as the second edition of the books in substantial part describes.
Yeah, so I was hoping to get you to talk about some other pretty interesting examples, and I think you touched on one there. Pat, when we had met, I guess about a week ago, you had mentioned a couple of pretty interesting examples of how this has been sort of used in practice to great success. I wondered if you could talk about a few of those. I remember one was Rebecca Modrak.
Oh, the plunger story. Rebecca Modrak is a studio art teacher and a studio artist who makes critical commentary with her work on the way in which modern capitalism distorts art, or that's probably not how she would put it. But so she made a piece of art in which she took a very pretentious advertisement from a Brooklyn firm that sells artisan equipment that is deeply inappropriate for Brooklyn, like large axes, as emblematic of a rural heritage that you are now going to evoke in your Brooklyn apartment. And so there's this little spot advertisement in which this guy goes on and on about this beautiful axe and the beautiful handle that reminds him of his grandfather and so on. And she makes a parody video of it in which the guy mimics the first guy gesture for gesture, word for word, only he's talking about a plunger, like the kind of plunger that you buy in the hardware store. And he goes on and on about this plunger and its form and its dimensions and so on. And so she is very worried because she gets a cease and desist letter when this thing is shown in a gallery. She gets a cease and desist letter from the Brooklyn firm that produces the first ad. And she asks us, because we're making a best practices code in the College Art Association to which she belongs. And we're like, Peter is like, no, don't talk to us. You are at the University of Michigan. Those are the people who did HathiTrust. They know fair use backwards and forwards. They'll have a really good time with this question. So she takes it to them. They start laughing. They're like, this is great. No, don't worry about a thing. So she doesn't. And then she publishes an article in an academic art journal published by Routledge. And the Routledge production assistant to the editor says, we don't have clearance for the half of your artwork picture that is not yours, but this other guy's, this Brooklyn advertisement. And the whole article is describing why this is a fair use in artwork. And she's like, did you read the article? And they're like, it doesn't matter whether we read the article. Our position is we are 100% clearance here at this publication. And she's like, no, take this to your lawyer. And they take it to the lawyers. It goes back and forth. And in the end, the lawyers say what they always do. They're like, oh, no, of course, that's fair use. We've always had that policy. Yes. Since you asked, yes, of course. And of course, the next person who comes in is going to have to do the same darn thing. But she actually got this thing published. And so it's out. And it's a story both of success, because it's a wonderful piece of critical artwork, and also a story of how it's really important to know your rights so that you can stick to your guns when people start overriding your rights. So, Peter, do you want to tell the Picasso story?
Well, I can definitely do that, but I want to tell a slightly different story to get us away for a moment from College Art Association and into some of the other documents. And this is really a story about videos of dance. There are around the United States several dozen important institutional collections that include all sorts of dance documentation, including extensive 16 millimeter and then videotaped records of dance and performance. And before we started working with the dance community on their code of best practices, the general rule that was observed by these collections was that although they were in the right in fulfilling their mission by holding on to this dance material and maybe occasionally allowing somebody who was able to travel to wherever they were in Western Massachusetts or Illinois or New York to actually see the material, they weren't about to make any of this documentation, especially the video documentation, available to the public because online, because, as you probably know or can imagine, the record of a dance performance, it's just layered full of copyright. There's the dance itself. There's the design of the sets and costumes. There is the music, and so on and so forth. And it wasn't until the dance community got together with our intermediation, went through and publicized, not as widely as some of the other codes of best practices, but sufficiently to reach its own membership, that we began seeing excerpts from dance documentation available broadly online from these archives. And if you want to look at an absolutely wonderful example of material that was literally liberated by the best practices approach, I would urge you to go to the website of the Jacobs Pillow Dance Festival and look at the wonders that are to be seen there in terms of the documentation of 20th century dance, all of which, by the way, is more or less copyright protected, an exercise that this institution and others have done in reliance not just on the fair use doctrine, but on the robust, centrist interpretation of that doctrine that they as a community worked to produce. So that's a story I love because it's narrow, it's specific, but it does exactly what fair use is supposed to do, and that is liberate important material for all to see and themselves to use.
Let me ask one question about our understanding of American fair use and how we see fair use abroad now, or similar ideas with fair dealing in some jurisdictions. And so there's the legal part of that. And then there's also sort of the practical piece of like how in those jurisdictions that have doctrines like fair use, how are they kind of navigating application of fair use in practice? And so, Pat, you had a pretty interesting recent trip and did some work in South Korea. And so maybe I can hand it to you first to talk a little bit about what's happening there. And Peter, then maybe you could talk a little bit more generally about kind of the international scene with respect to fair use.
Sure. That's also something that's in the book, by the way. There's a nice chapter in the book about this question, not quite up to date. So Pat and I will help to bring it up to date, but still useful, I think.
So there are some other places that have copyright fair use doctrine that looks like the US. Israel got it in 2008. Korea got it in 2011. And Peter, I just saw Neva at a conference. Neva is a friend of ours who is a scholar who's Israeli, who used the best practices model to make fair use usable for academics in Israel, because these exceptions and limitations that exist, whatever they may be, every copyright regime has them. But if nobody uses them, it doesn't mean anything. It just means that copyright gets more and more unbalanced because people in every country keep harmonizing with these international treaties, and they always harmonize towards more copyright. And then somebody says, you know what, which is what happened in Korea, if we're going to harmonize with all that extended copyright, I think we need the exceptions. And Korea fought very, very hard to get exceptions in 2011, along with all the extended copyright that the US demanded. But then I was like, well, then what happened? So I did a little study with some wonderful Korean academics during COVID, and hooray for Zoom. We did a survey that discovered that people really hadn't heard about it in the commercial part of the industry, which is probably not really surprising because most of that is fiction. It's like all those Korean dramas. But I wanted to know more about the documentarians because they're always the people who get really hurt if they're not able to quote real life, because that's their job, is quoting real life. So I thank the Fulbright grants for giving me a chance to go to Korea and meet these amazing scholars who are also filmmakers, who were able to introduce me to all these independent filmmakers who are just as adorable as American documentary filmmakers. They were so much fun to work with. So I put the link to our new project online, but we basically did a survey with them, and everybody wanted to answer this survey because I don't think people had asked them about this. We discovered the same thing with Korean documentary filmmakers that we had with US filmmakers. Oh, no, first of all, I don't know anything about copyright. So that's a lawyer's problem. Second, I wouldn't dream of doing something that was unprofessional. So I just have to clear everything. But all the people who didn't have money to clear everything, they were like, I guess I'll just keep it off the market, and maybe I'll show it at this film festival if they don't ask too many questions. Oh, the Korean Museum of Modern Art wants to buy my work. Oh no, I can't sell it to them because I haven't cleared all this stuff. So like there are all these stories that go on and on about like people just losing out. So we wrote up this stuff. We just did this. Our report is called How to Censor Yourself. We didn't want to like leave any ambiguity in the core message. And every film organization in Korea has a representative at that session because everybody wants to figure out what they're doing for next steps. They're very interested in the US model. We translated the best practices code of US documentary filmmakers into Korean. Koreans, they read English, but they don't love reading English. They operate purely in a Korean environment. So if you want to reach them, you should speak in Korean. So my two Korean collaborators, a wonderful film professor and a wonderful law professor, are really taking this forward. And they are truly inspired by what American documentary filmmakers were able to do. And it is the same process of discovery. It's not just a process of discovering, oh, I can use the law. It's a process of discovering things like, I have rights. I can speak. You can't tell me I can't speak. And really, for a place like Korea, which also is a place of a lot of open government censorship and a lot of other restrictions on freedom of speech, to be able to take at least this one off your docket is already a point of improvement. So I'm very excited about the way in which this project that we started 20 years ago and that filmmakers told us would never work, 20 years later is working really well in Korea and is inspiring documentary filmmakers there.
Thank you, Pat. Peter, do you want to jump in?
I can. There are all sorts of interesting and largely happy stories to be told about developments across the world. But before I tell my share, I do want to make clear one thing that is, we hope, made very clear in the chapter on international treaties and foreign laws in the book itself. And that is that although the existence and utilization of something like fair use, and I'll come back to that phraseology in a moment, is obviously very important to national culture everywhere. We are, thanks to the general approach that international copyright law takes to the array of different kinds of copyright laws that exist across the world, we are in the fairly happy position ourselves as creators, as information workers of all kinds in the United States, to be able to rely primarily, if not exclusively, on U.S. law in our analysis of what we have or do not have the right to do under fair use. French work is as subject to fair use or as part of a U.S.-based project as a U.S. work would be. That's called the principle of national treatment, and it's very important to us, but it doesn't solve any problems for people in South Korea or elsewhere who don't have a domestic fair use law for themselves. Well, several things are happening, and all of them are positive. In some places, the example of the United States and perhaps also the challenge posed by the U.S. codes of best practices has actually brought about movements to reform laws to conform more closely with the U.S. model. And probably the most interesting and startling example of that in the post-code period, if I may so refer to it, is the law of South Africa, where nothing now but the presidential signature is required to bring into force a new copyright law with a robust U.S.-style fair use exception built into it. And I think it's fair to say that the best practices documents had an inspiring, if not direct effect on that civil society movement. Elsewhere, the effects are more subtle. The effects of U.S. fair use, the emanations of U.S. fair use and of codes of best practices in particular. But I'll cite one that is of enormous importance, and that is the quiet but startling reinterpretation of the quotation right in UK law, which does not have fair use, which does have something called fair dealing, which is a kind of it's fair use light, if you like, but which has at its heart, as do the laws of almost all countries of the world, a quotation right. And in UK, the rights of creators have been enormously expanded by the administrative reinterpretation of the quotation right to embrace not all, but a large number of the things that U.S. creators do routinely under the guise of fair use. And then, of course, we have Canada, which also has a fair dealing right. But unlike the U.S. fair dealing right, the Canadian right, perhaps influenced by U.S. fair use doctrine, has exploded into what amounts to a full service user's right in copyright, which actually challenges its U.S. equivalence in terms of its potential and even actual reach.
I want to point out one thing. Peter's program on information justice and intellectual property, he has an annual meeting that is people on international from all over the world gathered to talk about exceptions and limitations. And these Canadian scholars who are also active in policy formation in the government came to those meetings and were in constant dialogue with experts like Peter and his colleagues over the years before this happened. So I just want to give credit to that institution for creating an interactive space where international scholars could take action as those Canadian scholars did. Thank you, Peter.
Appreciate it. So could go on, but Israel, as already been mentioned, as a country with a new and robust fair use doctrine, there are other examples, and I hope more to come. There's, again, a big discussion going on in Brazil about which way to go on these issues. And we'll see. We'll see what the next decade looks like. But I think the international prospects are actually quite encouraging.
There's one more thing, because Peter has a law office called Use Fair Use. And he runs it with Brandon Butler, who is an example of next generations of scholars and practitioners who Peter has been influential, as are you, Dave, are people who have interacted with these concepts and then taken them into new areas. The only other thing I want to say is I'm an annual donor to Authors Alliance, and I think everybody should be.
Thank you, Pat. I just want to thank both of you, Peter, Pat. Thank you so much for doing this. It was really great.
As for thank yous, a big thank you to Patricia and to Peter for such a great conversation today, and to Dave Hansen and Authors Alliance for co-hosting our session. Thanks all. Have a great day. Thanks for joining us on this journey into the future of knowledge. Be sure to follow the show. New episodes drop every other Wednesday with bold ideas, fresh insights, and the voices shaping tomorrow.